Beginning in the materials, the overarching philosophy for me when it comes to parenting plans is very similar to Robert Frost's poem, Good Fences Make Good Neighbors. What I've found over almost 30 years of practice, that parenting and co-parenting is best when there are defined boundaries. And the great thing about a parenting plan is it gives you tremendous flexibility and opportunity, obviously, to create boundaries for the parents so that they know what's supposed to happen when it's supposed to happen. All right, so let's get started. The key point on drafting a parenting plan is be patient. All right, what I recommend you do is you create your own vanilla form, which is a form that you're comfortable starting with on pretty much any parenting plan. It's already got the boring stuff already filled out, like alternating holidays. Only 1 out of 5 clients are going to have any kind of comment on holidays. All right. Next, a great way to explain to clients about parenting plans is that make it simple. There's 3 buckets of time: holidays, summer, school year. Not that complicated. Okay, it's terribly complicated, but you want to try to break it down in a simple way. Holidays, as we all know, pretty much every parenting plan in the state, not all, gives 50-50 parenting time to both parties, both parents. Summer, totally wide open for negotiation. If you represent the father and he wants to get more time, great place to go get some more time. And then school nights and school mornings. What we try to teach our clients is some terms that we can make sure that we're on the same page. So we teach them to refer it to how many nights out of 14, every 2-week period, and how many school nights out of 10 on a 2-week rotation. So pure 50-50 would be 7 out of 14, 5 out of 10. Okay. Now, and we really end up talking only about out of 10 because almost every time we're eliminating the weekends because it's going to alternate. Right. Now, this is a great opportunity for lawyers to make a difference in clients' lives. Right. Most of the time, we're supposed to be tremendous advocates, zealous advocates for our clients. But here, by doing a thorough job, listening to the client and helping them create a parenting plan that works for them in the event the parents can't get along, which is a lot, we're really doing a great service for them. The way that we don't do a good service for them is not listen, slap something together, send it to the client, have them say, well, yeah, this is fine, and then send it to the other side as part of a settlement or file it with the court. That's not what the parenting plan expects of good lawyers. So adding effort to it and adding patience to the process makes a big, big difference. Now, how do you get a client to give you the information you need? Because they don't know. More than a man in the moon, they don't know what you need to know. Well, you got to tell them, all right? We have a homework packet that we give the client. We ask them a lot of different questions. We ask them a wish list. In a perfect world, what do you want? Right? And if they got kids, usually the wish list, and I stole that from Barry Gold out of Chattanooga. We ask them to read the Tennessee Parenting Plan book. Like I said, I wrote that originally for clients and some of them blog posts that I put on my website. But ask them to read it and then ask questions. And if they don't read it, it's on them. And some people won't read anything we give them, but that's a different topic. All right. We also ask them to look at fully filled out permanent parenting plans, which we got 8 in the book. But if you've got some stapled up parenting plans, hand them that. You know, well, how I picked out the 8 in my book, I just put out I printed out all my parenting plans and sorted them out by general length of time and then picked 8. 2 were long distance, 2 were 50-50 time, and rest pretty simple. So that way they have an idea of what a finished product looks like. Also, I have in that book, chapter 16 includes a list of parenting plan restrictions that I've collected over my career and stolen from other states' parenting rights. So we've got 3 or 4 or 5 different provisions on either makeup time and or dealing with unrelated people, boyfriends and girlfriends spending the night in the same house with kids. We've got a lot of different items you can choose from in there. And we give that to the client as with some instructions. Tell us what's important to you and what do you want in there? What restrictions do you want? Now, the really cool thing about the restrictions, what we need to figure out is a balance between, do you really want to go to court to enforce that? And even if you're not going to go to court to enforce it, is that something you want to plant a seed in the other parent's head? Okay. Now, sometimes that works and it works really well. So the more that you can give a client in advance of drafting is best, right? Have a meeting, okay? Have a meeting just to deal with the parenting plan, right? Force yourself to commit time to it and force the client, right? And listen and draft right there. Now, you've already got your vanilla plan. You've maybe already made some changes to it and put some parenting time in there. And the toughest provisions to get right are school night, school mornings, because that's terribly important. So if your client wants 7 out of 10, 8 out of 10, then you may want to start out at 9 or 10. And Kate will talk more about negotiations later. But the point is having that language ready to go, it just takes more off your plate so that you can focus on listening to the client. Now, because what are you listening for? Concerns, values, needs, and priorities. It's that simple. And our goal should always be to make the first offer if we can. We almost always make the first offer in our firm, and you would not believe what a large percentage of what we put in the parenting plan never gets contested, right? That's my biggest tip for you today. First offer, make it perfect, exactly what your client wants, and then if the other side agrees to it, you throw a little bit of a party, and hopefully the lawyer gets invited. I only recommend making an appearance and showing up for 5 minutes, grab one drink, don't finish it, get out the door if you go to the post-divorce party, but that's a different topic. All right. So, and also ask when you get a chance, what's the other spouse, what's the other parent going to tell their lawyer that they're most concerned about? And usually they can give you some kind of idea. But you'd be surprised how many parents don't put effort into their parenting plan, especially when they're not represented by you. All right, temporary parenting. If you're in a contested custody case, temporary parenting, as you know already, is everything. I like to draft a full parenting plan as the temporary parenting plan. Because the net difference between a temporary parenting plan and a full parenting plan isn't that much. It's not enough to worry about. Okay. I can't even tell you what the net difference is because it's just not meaningful. And you want to get the parties, the parents, on the perfect permanent parenting plan schedule as soon as possible. Even if you file the temporary parenting plan and your local judge says, nah, I'm not ordering these parties to do anything before the divorce, at least you try. Okay. The failure to try is one of the biggest mistakes I think most family lawyers make across the nation. Well, the judge isn't going to award that. How do you know? All right. One of the things I do when I write about family law, I run it by some of the best lawyers in America that I'm buddies with through the ABA for the last 25 years. And I ask them, do you see this? Like, all the time. So I double check with them on that. That's absolutely true. All right. Now, one of the things that, and don't forget, tell clients that when you're talking about nights, that's the way I think most lawyers think about it. Where's the child going to sleep and get up? But child support worksheets refers to days. Tell them it's the same thing. Make sure that their terminology is on the same page with yours. And if you use a particular term in your practice, write it down and tell them, hey, this is not what you're going to see on the form, but this is the way I call it because my clients find it the most easily understood. All right. Custody disputes. All right. One of the things that I focus on in my practice is primary caregiver. Make sure you get a list from your client of the aspects of the children's lives that they're primarily responsible for, secondarily responsible for. And it's if you have to do depositions, it's a great set of questions because regardless of who you represent, because our job is zealous advocacy, right? Both parents are likely to be claiming, well, I'm primary caregiver. I may not wash the clothes, but I do all the driving. So, and then don't forget to go through your custody factors one by one. All right. Court of Appeals opinion after Court of Appeals opinion after Court of Appeals opinion are sent back for findings of fact and conclusions of law on the custody factors. All right. So, get in the habit of going through the custody factors with your client, whether it's a petition to modify or petition for temporary parenting plan, or you're going to court and need to do a pretrial memoranda or a proposed findings of fact and conclusions of law for trial. For all of these, and possibly even mediation, good lawyers, good mediators, good judges are going to be expecting to see an analysis of the custody factors factor by factor. And it forces you as the lawyer to focus on those factors and show your client that while no one factor controls, that's my favorite phrase from the Court of Appeals, while no one factor controls, they go ahead and list who wins each factor. I'm like, okay, it's good to have that detail, but that's not actually the analysis going on here, but that's a different topic. All right. Special needs. I wanted to give you an idea of what we do in our practice. There are very good special needs books published by the ABA Family Law section. And for each special needs child, we do the best we can to become experts on that need. All right, let's take autism. Autism is really rough because we don't know what we don't know about the future for the child. And each child fits on the spectrum. I'm not an expert on the spectrum, but I want the client to educate me on everything they know about that and speak to experts about what might be needed in the future in order to possibly create a trust, right? Why is a trust a good thing? Because usually one parent's the breadwinner, and that parent wants to contribute to the child's need. And once they get that account for an autistic child of $30,000, $50,000, that's pretty much fully funded unless something really weird happens. I mean, some autistic children can grow up to be adults and drive a car. Others are nonverbal. Okay. So having that trust in place, and maybe you could talk a trust and estate attorney to draft that for you. But the point is, it makes everybody comfortable. The obligor sees that there's an end to the road, and the obligor can check in on what those expenses, or especially if they're listed as co-trustee. That's my advice for special needs in a $10,000 or a 10,000 foot view. All right. Grandparent visitation time. I am a big believer in, if one of the parents or grandparents is going to spend a great deal of money on either giving legal fees to one of the parents, give them some grandparent time, a couple of weeks in the summer. It's free babysitting, right? And you're also making sure that the other parent doesn't get funded as much. So take care of the grandparents is one of my advice. And, you know, if you're really nice to them, maybe they pay for you to go to Disney World too. All right. Now, one of the tough topics I'm going to cover is when you get into mediation, explaining to the parents final decision making. Primary residential parent, as you know, is a strictly defined term that only deals with who has more parenting time. Now, we all know intuitively that a judge pays attention to PRP status and may apply that as a final decision maker tiebreaker. All right. Is that the law? No, it is not. So, but at the same time, the odds of a particular set of parents being in a dispute post-divorce over something that is important, and 9 times out of 10, that's public school versus private school or something else that's expensive. And usually that parent wanting the more expensive option is willing to pay. Okay. So we know the type of dispute most likely. And the courts, even though we got those other factors of who makes final decision making on those, judges will still look at PRP, and that matters only in the event of a dispute, because almost all decisions are day-to-day decisions under the parenting plan, right? What time do you go to bed? And the biggest one that nobody talks about in family law is these damn cell phones, because there's nothing we can do about it. You know, you can't put in the parenting plan subject to criminal contempt that a kid's got to turn off the cell phone by 10 o'clock. Well, they're going to find a way. Then they're going to use the iPad. And if not that, they're going to sneak on the computer. Okay. One of the things I thought about doing it as a parent was just turning off the Wi-Fi, you know, just cut them off. But they'll figure out a way around there because they can run the internet off the cell tower if they can get the extra internet. So having the parents on the same page for a cell phone is just an example of how things get unwieldy and could find their way into a courtroom on a dispute. And so PRP can be important, but is it worth going to trial over? Right? And I've had that. I represented a lawyer against a lawyer, and both parents were totally okay with 182.5, but they wanted PRP because there were lawyers. And the mediator tried to explain to them, you know, you're not really fighting over anything because, and the reason I brought up the cell phone or private school, you're going to, if you have a dispute that that's worthy of going to court, odds are you're either going to win or you're going to lose, and PRP status isn't going to make a huge difference, or does it? Which is a perfect ending for me. This is part art, part science. What the words say don't always apply when you get to a petition in a court hearing. Because what the judge wants to hear, A, is person by person specific for each judge. Why? Every judge has certain biases based on their history of their cases and their personal experience and life experiences and dealing with children in their own childhood. We're never going to know what's inside a judge's head. And the least way we can the least factor we could trust is when a judge tells us that. What they say and what they truly believe, in theory, should never be the same. Okay, because what they're saying should be for effect for the parents to try to coach them on how to stay out of court. All right. And my favorite, we got Judge Weiss over here in Shelby County, and I had a case in front of him. And it was about health insurance cards. My client had no health insurance cards, okay? And his first question was to the other parent, so why didn't you send the other parent the health insurance card? And of course, the other parent said, I didn't know they needed one. And then the judge looks at my client and says, did you even ask for one? And I look at my client and they said no. And I actually knew, because we had saved that as a gotcha in the courtroom. Well, it backfired, right? In theory, parents should be smart enough to know if they're the insured parent, send the insurance card to the other parent, and the other parent should be smart enough to ask when they don't have one. But they aren't and they don't. And so our job in this process is to help coach them through it, give them things to read, give them guidance, including but not limited to, what do you do when there's a problem? Okay. And what I tell them, communicate with the other spouse first. Tell them what you're worried about. Tell them what you're interested in. Tell them the documentation you need or access you want online, okay? Second, call me, I'll write that letter. Third, we take it to the judge, okay? If it's that important, we'll take it to the courtroom because good fences make good neighbors.